The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. This is Jennifer Schaus coming to you live from Washington, D.C. Thanks for joining us in our Webinar Wednesday series. Every Wednesday throughout the entire year in 2018, we are covering various government contracting topics, and the presenters range from industry experts, CPAs, attorneys, and other professionals who have knowledge of government contracting. All the webinars are complimentary. They're recorded. You can find them on our YouTube channel or on our website under the archived webinars section. If you do have questions today, you can send those directly to our speaker, who is Ed Delisle. His contact information will be on the last slide. It'll include his phone number and email address. Quick blurb about us. We are based in downtown DC and provide professional services for government contractors, both service companies as well as product firms. Our services range from market analysis reports, contract vehicles, including GSA schedules, the small business certifications, and other services listed there on the screen. We do host networking events and seminars throughout the year. You can find those on our website under the events section. A little bit about Ed Delisle is listed here on this screen. Again, he is our speaker today. I'm going to be covering the SDVO certification, which is the Service Disabled Veteran-Owned Small Business Certification. So we're lucky to have Ed with us today, and thanks again to our attendees for joining us, and I'll turn the controls over to Ed. Thanks,
Great,
Ed.
Jennifer, thank you. Sure, my pleasure. So our topic today is the changing landscape of the SDVOSB verification process. And what we're going to focus on today is SDVOSB, Service Disabled Veteran-Owned Small Business eligibility. There are lots of benefits in becoming SDVOSB eligible, not the least of which is qualifying for contracts that are set aside solely for SDVOSBs. And the rules governing eligibility are changing. They're consolidating and they're changing, and that will be the crux of what we'll talk about today. Go ahead, Jennifer, you can advance. But first, a little history. Going back prior to 2010, the Small Business Administration was basically the only game in town. SDVOSB eligibility was determined pursuant to the SBA's rules and the SBA's rules only, and it was a self-certifying, in fact it still is under the SBA scheme, a self-certifying process. You read the rules, you understand presumably what they say and what they mean, and you self-certify in a system for award management that you are an SDVOSB if you qualify under the SBA's rules. Prior to 2010, they were the only set of rules. Then Congress passed the Veterans Benefits Healthcare and Information Act of 2006 and directed the Department of Veterans Affairs to develop a program designed to make assisting veterans and service-disabled veterans a priority over other socioeconomic groups, and that was implemented by the Veterans First program in 2007. And once the Veterans First program was initiated, you had this dual system for SDVOSB eligibility. You had the VA, thanks to the Veterans Information Act and the Veterans First program, that had sole jurisdiction over eligibility, which primarily pertains to ownership and control of VOSB and SDVOSBs for VA contracts, and you had the SBA retaining jurisdiction over eligibility, again, primarily ownership and control, for all other federal contracts, that is, those that were not procured by the Department of Veterans Affairs. Okay, now initially I mentioned that the SBA's system is self-certifying. Initially, the VA system was self-certifying as well, but then that changed. Okay, you can advance the slide. So in 2010, the Department of Veterans Affairs began its process of what it calls verifying eligibility through a formal application process. It began doing so through CVE, which now stands for Center for Verification and Evaluation, and that particular administrative arm of the VA began to review applications as they came in, and it continues to do so to this day. And under the new system, which we'll talk about momentarily, it will continue to review applications pertaining to SDVOSB eligibility. It is a formal application process, and the information submitted includes documents like corporate governance documents. It includes tax information and other information like that will allow the VA to determine whether you are or are not eligible under its rules, and this would be for VA contracts. One important thing to note: only the Small Business Administration can determine size. So while the VA can determine under the current version and what will be the future version ownership and control based upon the rules that are in place, only the SBA itself can determine whether a company is small or not. As I mentioned earlier, the SBA system was and remains self-certifying. The VA system, of course, is not. So you have an application process, and that application process can take some time, but you have to go through it if you want to be eligible, at least currently eligible. And as we get into the new system, it will apply the same way moving forward. If you want to be eligible for SDVOSB contracts or VOSB contracts that are issued by the Department of Veterans Affairs. Okay, Jennifer, you can advance. Okay, so let's talk a little bit about these two parallel systems for determining SDVOSB eligibility, one for the VA and one for everybody else. So the VA has this self-contained system ever since the Veterans First Act was passed that pertains to just VA procurements. So the question is, are you an SDVOSB or a VOSB under the VA's rules, which would allow you to work on VA contracts set aside for SDVOSBs or VOSBs? Okay, that's sort of one box. You have to go through a special verification process at the VA to determine whether you are or are not eligible, and that's one piece. The second piece, the second box, pertains to everything else. So are you an SDVOSB under the SBA's rules, which would allow you to qualify for an SDVOSB set-aside contract issued by any other agency other than the VA? Again, as we said, that's a self-certifying system, but you have these dual eligibility issues, different sets of rules that you have to look to for purposes of understanding whether you are or are not eligible. And not surprisingly, we can guess what happened. You get an advance. So you have this mass confusion, right? So with these dual systems, you have definitional differences between the two that have created issues and problems over the course of time. For veterans and service-disabled veterans who would know any better, they would think that there'd be one system or at least one set of definitions for all SDVOSBs, and that makes sense. I mean, how hard could it possibly be to define ownership and control of a company, which are really the drivers of eligibility? You would think it would not be very difficult, and that's what many veterans and service-disabled veterans have thought over the course of the last 8 years or so. And what they have found is that these parallel systems have, in fact, created inconsistencies in definitions of ownership and control, and those inconsistencies have created problems for veterans and service-disabled veterans who may think that they're eligible but may not, in fact, be eligible under one set of rules or the other. Okay, you can advance. So you have different interpretations between the SBA's regulations and the VA's regulations regarding ownership and control. And this is where it typically comes into play, where a company is eligible under the VA's regulations and has been deemed to be eligible after going through its application process but then subsequently found not eligible under the SBA's separate set of regulations. And we're going to get into an example of what has occurred so you understand better the results that can come or flow from this. But this is what ended up happening. Okay, we can advance the slide. All right, so let's talk about what has happened. To give an example, or actually we're going to get into a few different examples of the problems associated with having this dual system or these two separate systems. Let's talk about Miles Construction. Now, Miles Construction was a case that I actually litigated a number of years ago, back in 2013. And the dispute was over transfer restrictions in the governing documents for the SDVOSB, which was Miles Construction. When it was initially, when the application that Miles Construction initially submitted to the VA was reviewed formally through the VA's SDVOSB verification process, everything was deemed to be okay. There were no problems in the governing documents. Everything was owned appropriately, and Miles Construction was verified by the VA as an SDVOSB. It ended up winning a contract from the Department of Veterans Affairs, and that award was challenged by a competitor. So as part of that challenge, the VA went back in and took a look at issues not only the issues that were raised by the party that was filing the protest, but it did a wholesale review of the entire application that had been submitted by Miles, and more specifically, the governing documents that were submitted as part of that application process. And what did it find? So during this re-review, the VA found a right of first refusal that the non-veteran owner had in the company, which the VA deemed was too restrictive on unconditional ownership as it was being defined at that time. And so it revoked, as part of the protest process, the VA revoked Miles Construction's eligibility. That was challenged, and thankfully for the SDVOSB here, Miles Construction, a judge determined that the way that the VA had interpreted its own rules was incorrect. And this was important for Miles Construction and for other SDVOs at the time, because a lot of these small companies depend upon investors, minority investors, to support operations moving forward. They may have all the know-how in the world, but they may not have the access to capital to be able to move forward with their business. If there are too many restrictions on an investor, however, you're going to scare those investors away, and they're not going to be interested in an SDVOSB if they have absolutely no control over their investment at all. And that's basically what the judge said in Miles Construction. Hey, look, these garden variety rights of first refusal are just fine, and they're not violative of any regulation that was then in place under the VA's umbrella. And so after that, what the VA started doing was it started to better understand the business aspect of running an SDVOSB and the VOSB for that matter too, and it began to relax some of the standards a little bit to allow minority owners a bit more in terms of rights over his or her investment. And that's the direction that the VA began to go. Well, the SBA, on the other hand, didn't do that, and it remained to be very restrictive as time progressed in terms of the ability of non-veteran owners to assert any rights whatsoever in an SDVOSB. And you saw that happen in this next case that you see referred to here, Veterans Contracting Group, Inc. And this really epitomizes what the problem has been for some time with this dual SDVOSB eligibility system that's in place, and it has been in place for quite some time. So the Veterans Contracting Group, Inc. is actually a series, versus the United States is actually a series of cases. There are 4 of them, and they all involve the same project. It was a Corps of Engineers contract that had been set aside for SDVOSBs. So it was not a VA procurement, it was a Corps of Engineers procurement. And that's an important distinction. So veterans contracting had already been deemed eligible by the Department of Veterans Affairs and was in their electronic database as a qualified SDVOSB. It checked every box that the VA deemed appropriate for purposes of determining that Veterans Contracting Group was in fact an SDVOSB. Despite that, the protest challenged, so Veterans Contracting wins this Corps of Engineers contract, and it's challenged, it was protested. And as part of that challenge, the protesting party made the argument that Veterans Contracting was not, in fact, SDVOSB eligible. And so the SBA did its own review of Veterans Contracting Group's eligibility. And they ultimately ended up deeming Veterans Contracting Group ineligible under the SBA's ownership and control rules. And what was the problem? Well, the problem had to do with what happened to the SDVOSB's ownership interest shares in the company upon his death. The way that the ownership documents were written, the ownership interest would revert to the non-veteran minority owners, and they could then do with the company as they wished. The SBA determined that, well, that's too restrictive on the ownership interest of the service-disabled veterans, so we deem that, we decide based on that 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 Veterans Contracting is not an eligible SDVOSB. And not only did they lose the contract, but at least initially, the company also lost its verified status with the VA because of a separate regulation which requires an adverse SBA ruling to be provided to the VA for further action. And that further action, in this case, at least initially, was that Veterans Contracting lost the contract and lost its VA eligibility as an SDVOSB. Now, the court ultimately ended up stopping, in one of these actions that I mentioned, again, there were 4 of them, the court ended up stopping the VA from removing Veterans Contracting from its SDVOSB database, but what a mess. So all this confusion about being eligible or not being eligible got the attention of Congress. If you can advance the slide. So Congress decided to get involved, and as part of the National Defense Authorization Act of 2017, it decided it was going to take a stab at consolidating this system that is presently in place and making it simpler for SDVOSBs to understand whether they are or are not eligible. As part of the NDAA of 2017, there was a requirement that a standardized set of definitions for SDVOSBs and VOSBs be established between the SBA and the VA. So as part of the NDAA of 2017, there was direction by Congress for the VA and the SBA to get together and put together one set of rules. And the way this system was designed to work based on what Congress wanted was, okay, well, the VA is going to continue to have its verification process. All right, so moving forward, Congress says, okay, VA, you're going to continue to do what you do. However, you're going to use the SBA's SDVOSB regulations, but not the ones that are currently in place, a new set of regulations that the two of you are going to come up with and agree upon. And in fact, we're going to talk about this shortly, but that's exactly what happened. We're going to go through what some of the proposed rules are momentarily. The other thing that Congress demanded was that any ownership and control challenges over eligibility would be determined by the SBA's Office of Hearings and Appeals. As it currently stands and as it has been operating, eligibility challenges based on VA action. So if you're attempting to become eligible under the VA's or through the VA system, the appeal process would go through the VA. No more moving forward, at least starting on October the 1st of this year. The Office of Hearings and Appeals at the SBA will hear appeals of that nature. So that actually is already in place. There was a final rule issued with respect to that, and OHA will begin hearing appeals beginning on October 1st of this year. Can you advance the slide? Okay, so we just talked about the final rule regarding OHA. It was issued on March the 30th, and OHA will begin hearing challenges regarding eligibility on October the 1st. You had a set of proposed rules come out on January 29, 2018, and those proposed rules pertain to this new consolidated set of regulations that will govern, or some form of them will govern, because it's only a proposed set of rules. But you will have these consolidated set of rules in place moving forward, and so you got one rule book as opposed to two to take into consideration if you want to be a SDVOSB or VOSB and comply with the rules and become appropriately eligible. If we can advance the slide. Okay, so let's talk about what some of the proposed rules say. Now, generally speaking, in order to be considered an unconditional owner of an SDVOSB, the service disabled veteran must own at least 51% of his or her company. It doesn't have to necessarily be one veteran or service disabled veteran. It can be one or more, but the total percentage has to be 51% or more in terms of ownership. There is in the new consolidated rules a surviving spouse provision, and this came from the old set of VA rules. I guess technically still the current set of VA rules, and it caused a lot of confusion over the years. And I have a client, for example, who they're an SDVOSB. The father passed of a service disabled, a service related disability. And under the old and current VA rules, the surviving spouse is permitted to carry on and operate as an SDVOSB, and that's what the company was doing. But what the company did not realize was that the SBA did not have a corresponding and does not have a corresponding provision in its rules. So while the company was fine pursuing VA procurements, it ran into a big problem pursuing non-VA procurements and had no idea that there was not a corresponding provision under the SBA's rules. So, for example, the company went after a few Corps of Engineers projects, but the rules governing those projects are different than those governing the VA, and they ran into some issues and problems. Well, under the consolidated rules, you're going to have this surviving spouse exception where if a veteran was deemed by the VA to have had a 100% service-related disability and passes, or the veteran died as a result of a service-related disability, then a surviving spouse can assume ownership of that company upon the veteran's passing and continue to operate as an SDVOSB. So that's a carryover from the old VA rules, as is how the way in which profits are handled. It's also a carryover from the old VA rules. And what the consolidated regulations say is that profits from the company must be commensurate with the percent of ownership that the veteran or service disabled veteran has. So if it's 51%, then and it's one veteran, and that veteran must be entitled to 51% of all of the company's profits, and the same holds true if it's any percentage above and beyond 51%. The service-disabled veteran or veteran must be entitled to the full value of the percentage of the company that the veteran owns upon sale or dissolution. That's another one. You'll see that here on the slide, but there can't be a dilution of value as part of any sale or dissolution. That's also in the consolidated set of rules, and that's not a big surprise. Most of the, you can go ahead and advance, Jennifer. Most of the issues which come up, and they come up now, and they come up as part of the consolidated rules, come here when we're talking about unconditional control. I mean, generally speaking, an SDVO must control the management and daily business operations of the company to be considered SDVOSB or VOSB eligible. And that's a very general definition, and the devil's always in the detail. Some of the details in the consolidated set of regulations are interesting, and I want to talk about those briefly. So there is a portion of the consolidated rules which gets into supermajority provisions. And supermajority provisions have, generally speaking, always been a no-no when it comes to SDVOSBs, because having them in there could allow a non-veteran minority owner to block an act of the service-disabled veteran by refusing to vote with the veteran in instances where supermajority votes are required. Okay, so generally speaking, they're frowned upon and can lead to issues and problems in terms of becoming eligible. All right, what's interesting about the consolidated rules isn't the fact that they talk about supermajority provisions and the fact that they're frowned upon, but what's interesting is that the consolidated rules state that it's the applicant's obligation to point out to the VA at the time that it or he or she submits its application that supermajority provisions actually exist, if they exist. It's not clear to me what would happen based upon the rules if you fail to do that. Could they reject your application if they find it and you didn't point it out? I suppose it's theoretically possible. I would hope not. But I thought it was very interesting that they actually point that out in the consolidated set of rules. There are also indices of non-veteran control that are identified as part of the rules. We can talk about some of those here. There is a rebuttable presumption that if the veteran or service-disabled veteran does not work during normal business hours for the company, that he or she does not control the company. And that's a rebuttable presumption. So if the service-disabled veteran or the veteran provides evidence that control is still there despite not working during normal working hours, the company can still become eligible, but it's discussed as part of the as part of the consolidated set of rules, and so you have to keep that in mind. Generally speaking, the veteran or service-disabled veteran has to be the highest paid employee. Again, that's something that can be rebutted if you have a good reason as to why that should not be the case. An SDVO company should not share space with another company in the same line of business where the owner of that company also has some ownership interest in the SDVO company. That makes sense, and that borrows, at least in part, from the SBA's analysis that it conducts in terms of affiliation, and so it wasn't a surprise to see that in the consolidated set of rules, but it's something that folks need to be aware of because it's specifically identified in there. One that I thought was interesting, and I don't agree with, veteran proximity. So this is interesting. So and this is also a rebuttable presumption. So there's a rebuttable presumption that if the service-disabled veteran does not or is not located within a reasonable commute to the firm's headquarters and or job site locations that the service-disabled veteran does not control his or her company. Well, that's interesting, and it's sort of contrary to a lot of how business is conducted today. Telecommuting is a real thing. Email, text, other electronic means of communication, it's used all the time. There was a case a few years ago, KWV Inc. versus United States, and that was a case that interpreted the VA's rules pertaining to control. And just to give a little bit of background about the case, so the case was about a construction company based in Rhode Island. It was an SDVOSB company, and the company was performing work in various different locations. The service-disabled veteran was a Korean War vet, and he spent about 6 months out of the year down in Florida. And he kept track of all of his construction projects, which were spread out in a large geographic area, through email and telephone and text and all these sorts of ways that are very natural for people to use and to keep track of things. And his ability to control was challenged by a competitor. It ended up going to a judge, Court of Federal Claims judge, and that judge determined that, look, you know, in this day and age of technology, you don't have to be at the project site or at the home base every single day in order to control what's going on and to assume control over what's going on for your company. Yeah, there are important things that you have to attend, important meetings that you have to go to, important job site functions that must be performed by you as the service-disabled veteran. But by and large, things can be done using electronic means of communication, and that in and of itself is not a basis to determine that somebody is ineligible as an SDVOSB just simply because those electronic means of communication are used. And so this particular provision in the consolidated rules certainly flies in the face of that case, and it flies in the face of sort of how we operate in this day and age. I don't know if, and there's been an awful lot of talk in the community about, in the community in which I operate, about that provision of these consolidated rules. Whether it ends up being in the final set of rules, I don't know. We'll have to wait and see. But there's been an awful lot of discussion about that. And now let's talk about these extraordinary circumstances, because this is important too. So in the consolidated set of rules, the SBA indicated that it will not find a lack of control where a service-disabled veteran does not have the unilateral power and authority to make decisions in what they call extraordinary circumstances. And there are only 5 of these extraordinary circumstances: adding a new equity stakeholder, dissolution of the company, sale of the company, merger of the company, declaring bankruptcy. So non-veterans can have a say and some modicum of control over those 5 things, and the company can still be deemed eligible for SDVOSB status. Okay, but those are the only 5 things. And in fact, in the consolidated set of rules, the comments are very clear. It says that, let's see if I can find it here. Under the proposed rules, these 5 circumstances would be exclusive, and SBA would not recognize any other facts or circumstances that would allow negative control by individuals that are not service disabled. So that's it. It's very explicit and clear that these 5 exceptions are the only extraordinary circumstances, at least under the proposed set of rules, that would be considered by that should be considered by the VA as part of its eligibility determination, and if there are any subsequent review by OHA, which is under SBA's umbrella, then by SBA through OHA. So we're going to end up having a consolidated set of SDVOSB eligibility requirements. That's good. That's good. It's certainly better than the alternative which we've been living under, which is this sort of dual system that we talked about. But there are some things that hopefully will be improved moving forward that will make it a little bit more SDVOSB friendly and make a little more sense. And I mentioned some of those to you today. To the extent that anybody has any questions, you can feel free to contact me at some point after our webinar is complete, and I'd be happy to answer any of those questions.
Great presentation, Ed. Thanks so much for the insight and your excellent knowledge on the topic. If anybody does have questions, please contact Ed directly. His phone number is here on the screen, as well as his email address. Next week on Wednesday, we have a double header. At 12 o'clock, we are covering GSA schedules, Do I Qualify? And then at 12:30, we're going to go through a series of must-do or must-have steps in federal government contracting. Again, the full schedule's on our website under the webinar section, and the schedule is already complete for the entire year. So you can kind of search and pick topics that are relevant to you. And again, all the recordings are there as well. Thanks again, Ed, for a great presentation, and thanks to all of the attendees from today. Again, if you've got questions on the SDVO verification or need help with that, Ed is certainly a great person and resource to go to for that and other government contracting matters. Thanks again, Ed, and thanks again, everybody else.
Great, thank you.